Hello, I'm Cornell Clayton. I'm the director of the Thomas S. Foley Institute at Washington State University. And on behalf of the Institute, I want to welcome you to our continuing series on the 2020 election. We've been bringing you some of the country's leading political experts talking about various aspects of the campaign and the election. All of these events have been taped and streamed live to our YouTube station. You can see our previous events there or watch our upcoming events. I want to thank the College of Arts and Sciences at Washington State University for supporting this series and supporting the Institute and its programs. If you'd like more information about either this series or any of our programs at the Foley Institute, I encourage you to like us on Facebook and you'll receive information about our upcoming events, or you can go to our website, foley.wsu.edu. So today's event, it's perfectly timed. It examines the nomination of Amy Coney Barrett to be a justice on the U.S. Supreme Court. A month ago, President Trump nominated the 48-year-old Barrett to replace Ruth Bader Ginsburg, who passed away in September. As voting was underway in the presidential election, Barrett's nomination has been rushed through the Senate. It was voted out of the Judiciary Committee by Republicans just last Friday, with all Democrats boycotting the process. Barrett is now likely to be confirmed by the full Senate later today along a mostly partisan line vote. Like Trump's last two appointments to the court, Neil Gorsuch and Brett Kavanaugh, Barrett is young and conservative. Unlike them, both of whom replaced other Republican-appointed justices, she will replace a Clinton appointee who was the line of the court's liberal wing. Barrett likely will have a greater impact on the ideological direction of the court than any nominee or appointment in more than a generation. Democrats are furious that the nomination was pushed through so close to an election, and they've already started talking about court packing and other institutional responses should they win next week's election. So what should we make of Barrett's appointment? Was the process legitimate? What will be the effect on the court's decision-making? And how will the appointment impact the election and voting? So fortunately, we have a perfect guest to talk about some of these questions. Amanda Hollis-Brusky is an associate professor in the politics department at Pomona College in Claremont, California. Her research examines constitutional law, Supreme Court politics, and the conservative legal movement. Amanda's work has appeared widely in the leading journals of political science. Her first book, Ideas with Consequences, The Federalist Society and the Conservative Counter-Revolution, published by Oxford University Press, won the American Political Science Association's C. Herman Pritchard Award for the best book published on law and courts. Her most recent book, Separate but Faithful, The Christian Right's Radical Struggle to Transform Law and Legal Culture, also published by Oxford University Press, examines the rise and efficacy of the conservative Christian legal movement. Last month, Amanda was asked to provide expert testimony before the House Judiciary Committee about judicial independence and the causes and consequences of court capture. In addition to her scholarly work, Amanda is a frequent guest on various media outlets and has appeared on NPR's All Things Considered, the BBC World News, and in the pages of the New Yorker, the Los Angeles Times, the San Francisco Chronicle, the Washington Post, and New York Magazine, among other places. She's a regular contributor to the Politics Roundup on Air Talk with Larry Mantel, and she is the editor of the Monkey Cage blog at the Washington Post. Let me also say that Amanda has been a previous guest at the Foley Institute, so I want to personally thank her for agreeing to come back again virtually this time on such a short notice. I also just mentioned that her new book has just come out, the book on Separate but Faithful. And I just picked it up over the weekend and started reading it. It's a terrific read, so I can highly recommend it. Professor Hollis-Brusky, she's going to speak for about 20 minutes or so, and after that we'll have time for discussion. If you have questions, I encourage you to send those to me at TS, as in Tom S. Foley, tsfoley@wsu.edu. Again, tsfoley@wsu.edu. So Amanda, it is great to see you. I'm going to turn the time over to you now, and I'll be back later with some questions from the audience.
Thank you. Thank you, Cornell, for that introduction. Thank you to Richard and everyone at the Foley Institute for inviting me to speak and participate in this truly exciting and dynamic election year lecture series roundup. As Cornell mentioned, the timing could not be more perfect. Now, courts have always, or at least long occupied, a unique position in American government and American politics. As far back as the 1830s, Alexis de Tocqueville famously observed that scarcely any political question arises in the United States that is not resolved sooner or later into a judicial question. Almost 2 centuries later, this observation rings truer than ever. With polarization and gridlock in Congress, individuals and organized interest groups are increasingly looking to the judicial branch to carry out their policy agendas. The Supreme Court, itself intensely divided along partisan lines, has demonstrated a willingness to play a more hands-on, active role in politics. In the last decade alone, for example, the High Court has issued closely divided and divisive rulings on voting rights, campaign finance, gun rights, contraception, marriage equality, immigration, LGBTQ discrimination, abortion, affirmative action, housing discrimination, church-state relations, and healthcare, among other issues. Now, the current partisan split on the Supreme Court is unprecedented. It's also likely to become the new normal, absent major structural reform to the court, which Cornell mentioned is in the air. The political changes that underlie the Supreme Court's partisan turn, changes I'll talk about briefly in my remarks, mean that presidential elections will matter more for the Supreme Court than ever before. Although this election, as we'll talk about in a moment, may end up mattering less than it otherwise would have. So how did this happen? Why has the Supreme Court seemingly become more of a partisan political issue than it was even in the early 1990s? Well, the culprit, as many political scientists have noted, is in our politics. Several trends in our politics have conspired to make the Supreme Court a focal point in partisan politics, and therefore a focal point of election year politics. Now, because we have a politically selected judiciary, over time, the courts will tend to look like the party or the parties that win elections. As your resident court experts, Cornell Clinton and Michael Salamone, write, during the past 40 years, American politics has been dominated by a partisan regime that is at once more conservative than the New Deal regime it replaced, but also more closely divided and polarized than any in more than a century. Since 1980, for example, the ideological distance between the Democrat and Republican elites has grown at a remarkable rate. Prior to Ronald Reagan's rise to power, there was no meaningful gap in the median liberal conservative scores of the two parties, with both Democrats and Republicans in Congress occupying every ideological niche. So you can think of it like this: some conservative Democrats, some liberal Republicans, but the parties, as one political science famously said, tended to dance cheek to cheek, right? Fairly closely aligned. Fast forward 40 years, and there's currently no ideological overlap between the two parties in Congress. They look like this. The most liberal Republican is still to the right of the most conservative Democrat, and vice versa. Political scientists refer to this phenomenon as political polarization. Now, we've also seen a rise in what's referred to as affective polarization. Now, this is the tendency to be hyper-aware or conscious of one's own partisan attachments, one's own partisan identity, and to view the other side with hostility or suspicion. This is also sometimes called party tribalism. Now, because, as political scientists are fond of saying, the Supreme Court follows the election returns, our polarized politics have produced a polarized, ideologically divided, and partisan judiciary. In other words, all of these dynamics in our politics, polarization, partisan sorting, party tribalism, are reflected in the legal and political elites who select judges and justices. And as Neil Devins and Larry Baum show, it's also reflected in the social networks that are critical to grooming and identifying appointees to the federal bench and to the Supreme Court. Networks like the Federal Society for Law and Public Policy Studies, about which I wrote my first book. Additionally, because the two parties are so electorally competitive, for example, control of the White House and control of the Senate has vacillated back and forth between Republicans and Democrats since the early 1990s. And because of the rise of strategic retirements by judges and justices, that is, judges retiring under a same party president or ideologically sympathetic president, we've inherited a correspondingly divided and polarized Supreme Court. What does that look like? Well, since 2010, the Supreme Court has been strictly divided along partisan lines, not just ideological lines, partisan lines, with every justice appointed by a Democrat voting more liberally than every justice appointed by a Republican president, and vice versa. Now, far from being the historical norm, political scientists have shown that this partisan divide is out of step with traditional patterns of voting and alignment on the court. Now, the Roberts Court has split or sharply divided, so 5-4, 4-4, 4-3, on nearly one of every 5 decisions it's rendered, which is the highest rate of division of any court since the New Deal. Additionally, these partisan voting blocs on the Supreme Court are more homogenous than ever, with Democratic appointees voting more and more often with their fellow partisan appointees and Republican appointees doing the same. As Brandon Bartels notes, a vicious circle exists between polarization on the Supreme Court and the nomination process, with the Republican Party desperately trying to hold on to and indeed expand their majority on the court, and Democrats trying to limit their gains by any means necessary. We can understand these dynamics in the context of Francis Lee's excellent work on insecure majorities. Because control of the White House and Senate are almost always up for grabs these days, both parties have incentives to go nuclear, to undercut the other party, to engage in what scholars refer to as constitutional hardball when a vacancy on the high court opens up. Now, we've seen this drama, this high-stakes chess match between the parties over the future of the court, play out several times just over the last 4 years alone. In the Mitch McConnell-led Senate standoff over President Obama's nomination of Merrick Garland to fill the seat left vacant by the sudden death of conservative stalwart Antonin Scalia in February of 2016, the Senate Republicans, citing what they called the election year rule, said the people should vote and decide which party will get to fill that seat. Garland's nomination languished in the Senate, while then candidate Trump, working closely with the Federal Society for Law and Public Policy Studies, presented a list of potential judges to the people of the United States, thereby tying a vote for Trump to a vote for a conservative Federal Society judge on the Supreme Court. That move was unprecedented, but by all accounts, that move worked. While Democrats tried to throw procedural hurdles up to slow or block the nominations of both Neil Gorsuch and then Brett Kavanaugh to the Supreme Court, after McConnell and Republicans removed the filibuster for Supreme Court nominations, which again is another unprecedented move in this historic high-stakes chess battle, the Democrats as the minority party have been powerless to stop them. Which brings us to today and the imminent confirmation of 48-year-old Amy Coney Barrett to the Supreme Court of the United States just 8 days before what looks to be the most consequential presidential election, at least in my lifetime. The Senate Republicans announcing just days after the death of liberal hero and icon Ruth Bader Ginsburg that they plan to fill her seat with a Trump appointee 6 weeks before the 2020 presidential election, a move that directly contravened their own election year rule, is the latest episode in a tit-for-tat partisan escalation over the Supreme Court that's been the result of political dynamics decades in the making. It could also be, as I've said to reporters, and I said at a panel this past Friday at Florida Law School, the tipping point, the chess move that prompts the Democrats, if they manage to secure the White House and a Senate majority, to change the rules of the game. I'm speaking here of the very real prospect, and we're already hearing talk about it at the highest levels, of significant structural reform to the Supreme Court and to the entire federal judiciary. This could take many forms, court reform could, but the most provocative that we're hearing is what's known as court packing, expanding the number of seats on the Supreme Court so that a prospective Biden administration could then fill those seats with ideologically sympathetic judges. So why are we talking about court reform now? As I've just mentioned, these dynamics have been decades in the making. Well, in part, I think this has to do with who the nominee is and who she is replacing on the Supreme Court. We ran a piece last week at the Monkey Cage by judicial politics scholars Jason Windett, Jeff Hardin, Morgan Hazelton, and Matthew Hall, whose ideal point estimates place Amy Coney Barrett in ideological lockstep with Antonin Scalia. As we know, Barrett clerked for Scalia, so that's not a surprise. And in fact, these estimates place Barrett to the right of Scalia on certain issues, such as the Second Amendment and guns, and religious liberty issues. If these estimates are correct, then Amy Coney Barrett, replacing Ruth Bader Ginsburg, represents the largest ideological swing in a single seat on the Supreme Court for the entire period for which these scholars have data. That means that Barrett's appointment will move the current court further to the right than Clarence Thomas's replacement of Thurgood Marshall in 1991. And that to me is simply astounding. There's also the very real fear that Barrett, because of her well-known and self-professed identity as a conservative Catholic, will provide the vote that either irreparably guts or overturns Roe versus Wade, and or that she will join recent conservative appointees Gorsuch and Kavanaugh, along with Thomas and Alito, to abruptly overturn the right to same-sex marriage, declared in 2015 by the now retired Justice Anthony Kennedy in Obergefell versus Hodges. These concerns were in no way alleviated during Barrett's confirmation hearing, during which she was described, as my colleague Paul Collins put it, as next level evasive about how she might treat certain precedents. But I also think this has to do with Barrett's nomination, securing a 6-3 Republican appointed supermajority voting bloc, a supermajority. There's no longer a Justice Kennedy. There's no longer any single swing vote. So the Democrats and the liberals who have sorted into that party are facing the very real prospect of a Supreme Court that is poised to push the conservative counter-revolution further and deeper for decades to come. So think more rights for corporations and gun owners, the crippling of labor and labor unions, deeper cuts into the administrative state and the regulatory and oversight capacities of Congress, and huge exemptions carved out for individuals and business owners who decline, for professedly religious reasons, to comply with anti-discrimination statutes. Think Masterpiece Cake Shop here, right? The refusal to bake a cake for a gay couple, or Hobby Lobby, the refusal to provide contraception for female employees based on professedly religious reasons. Now, this also means that regardless of the size or scope of the electoral mandate that Joe Biden administration would have to pursue, an ambitious legislative agenda, so that means regardless of the size of the victory that Biden may secure in the upcoming election, and the mandate that that administration would have to, for example, address coronavirus, to address the climate emergency by passing something akin to the Green New Deal, to address the epidemic of gun violence by passing gun regulation, to pass criminal justice reform and police reform so that bad cops can be held accountable for excessive use of force, that regardless of the mandate Biden would have as a result of this election, it means that 5 men and 1 woman on the Supreme Court could strike down all or part of that entire legislative agenda based on what they call an originalist or sort of cramped reading of the United States Constitution. Now, the last time something like this happened, in 1937, we faced a constitutional crisis, complete with the threat of court packing by FDR, who had just won the biggest electoral victory in history in 1936, and who nevertheless faced a recalcitrant Supreme Court who was set on thwarting FDR's wildly popular New Deal legislative agenda. As we all know, FDR's court packing plan failed, but as history tells us, it succeeded in getting at least one justice, Justice Owen Roberts, to flip, to start voting with the liberals and to begin upholding FDR's legislative agenda. Now, any plans for our Justice Roberts, Chief Justice John Roberts, to save the court by switching sides have now been scuttled with the appointment of Amy Coney Barrett. Right? It would take more than 1 vote to save the 9. It would take 2. And as Laura Kalman, a legal historian, said on our panel this past Friday, history rarely repeats itself, but it does tend to rhyme. And so this is where we find ourselves now. And the question that Democrats and court watchers are asking now, as we all stare down the impending reality of another constitutional crisis, is what rhymes with 1937? And the answer that Joe Biden has given is a commission to consider possibilities of reforming the court. But of course, that means he first has to win the election. So I'll leave it there, and I'm thrilled to answer questions and engage in the conversation. Thank you.
Great. Hey, thanks, Amanda. That's a terrific wrap up. So I got lots of questions about possible reforms, but let me begin with a question about what do you really think is the likely impact of the Barrett appointment in terms of actually turning over some of these important precedents like Roe versus Wade, for instance, or Obergefell or others. There's a huge debate amongst the conservatives about stare decisis and overturning precedent, and it's unclear to me where Barrett really stands on that. And so I wonder what your thoughts are.
Yeah, that's a great question. So it's an interesting, I would say, turn within the conservative coalition. When the conservative coalition kind of grows up, they grow up alongside the Reagan administration. And there are conversations about judicial restraint. And judicial restraint really is a way of attacking the Warren Court, right? The court that brought us Brown versus Board of Education, Miranda v. Arizona, Griswold versus Connecticut, created the right to privacy, found greater rights, due process rights for criminal defendants, expanded the understanding of the 14th Amendment's Equal Protection Clause. So that all fell under what conservatives would call the umbrella of judicial activism. These were judges creating new rights, overturning old precedents, reading their own subjective policy preferences into the Constitution in ways that really went beyond what the judicial role should be. The judicial role should be restrained. The judicial role should be minimal, right? The court shouldn't run around creating new rights or striking down popularly elected legislation unless they absolutely have to. And so the conversation was all about judicial restraint in the 1980s. Well, lo and behold, the conservatives over the last decade have secured a fairly big majority on the Supreme Court and on the lower federal courts. And the dialogue shifted, right? Conservatives are no longer wedded to judicial restraint. They are now open proponents of what they call judicial engagement, right? Which looks a whole lot like what they used to call judicial activism. And judicial engagement means it doesn't matter how long a precedent has been on the books. Stare decisis doesn't matter. It doesn't act as a barrier to correcting the mistakes of those liberal courts and those liberal justices that got the Constitution wrong. If you want to be faithful to the judicial role, you have to overturn all those precedents and you have to get the law right. So folks like Randy Barnett in the Legal Academy, Clarence Thomas on the Supreme Court, and Alito have openly embraced this idea of judicial engagement over judicial restraint. And so it remains to be seen where Amy Coney Barrett will fall on that. But if she is in the Alito-Thomas camp, it's very likely that she won't view precedent as a barrier to her acting, that her objective will be to get the law right, to correct the mistakes of the past, even if that means overturning and undoing 50, 60, 70 years worth of Supreme Court decisions.
So let me just follow up. It's no surprise, I think, that Chief Justice Roberts is concerned about the institutional impact on the court of overturning lots of precedents or taking on a future Biden administration should that occur too frontally. So what do you think his influence will be? Do you think he'll be able to slow down a conservative majority and find middle ground, or do you think now that it's a 6-3 majority, he's going to be shunted aside?
It's a great question. And since the retirement of Anthony Kennedy, what we've seen, or at least what it appears for court observers, we don't know what's really going on, but it appears that Roberts has moved into that institutionalist role, that he's been willing to give the conservatives some victories, but not move the law too far, too fast. He's been willing to side with the liberals on a few decisions. But really what he seemingly cares about right now is preserving the institution of the Supreme Court, preserving its legitimacy, and shielding it from potential attacks from observers who look at the court and say, well, it seems to me that all you're doing is enacting your preferred policy preferences. Why should we listen to you? If the Republicans always vote with the other Republicans and the Democrats always vote with the other Democrats, then what is the court really other than an extension of the political branches that we can't vote out? Right? So I think Roberts moved into that role with the retirement of Anthony Kennedy, but with the appointment of Amy Coney Barrett, he needs to get one other justice to be convinced to save the court, right? To move with him on various decisions, to try to keep the court from going too far in either direction, and to try to protect it from these very real attacks and threats to change the very institution of the court itself.
Right. So several people have been asking about the commission that Biden's proposing and what possible reforms could pass or would be constitutional. So Aziz Makani, for instance, asks whether or not there's been proposals to limit the service of justices to 10 years, or proposals to expand the pool of justices or to limit the pool of justices that can be selected from. Would either of those proposals be constitutional, do you think?
So the most constitutional proposal is also probably the most provocative and the most radical. It is very clear constitutionally that Congress can change the number of seats on the Supreme Court and on the lower federal courts. It's done so throughout history, right? There's nothing magic about the number 9. It's been as few as 5 and as many as 10. So we know that Congress can do that. The question mentioned something like term limits. There are many different proposals for how that might look. The one that I'm most intrigued by is one that would implement term limits by statute. So it wouldn't require a constitutional amendment. And what it would do is actually elevate lower federal court justices for a fixed term to the Supreme Court of the United States, let's say 12 to 18 years. And then once they were done with their term, they'd rotate back down and continue serving on the Court of Appeals, should they decide to do that. Some argue this takes care of the lifetime appointment language in the Constitution, because these judges technically are appointed for life. But just as the Supreme Court justices used to ride circuit before there was a number of circuit court judges who could hear all those cases, they would take their horses and ride down to the circuits and actually hear cases on the circuit and then return to the Supreme Court. This proposal would reverse that and actually have appellate court judges ride the Supreme Court for a fixed number of terms. Now, the problem here is if the Supreme Court, the majority of the Supreme Court doesn't like that, the constitutionality of this proposal would be heard by them. So there's a very good chance that they could strike down the very proposal to term limit themselves or term limit future colleagues in future seats on the court. There's a ton of really interesting proposals I'll be happy to talk more about in depth. Ganesh Sitaraman has written a very famous law review article that was then picked up by Pete Buttigieg during his campaign for the Democratic nomination for president. And it's called the Balanced Court Proposal. And it's a 5-5-5 proposal. And it proposes expanding the number of Supreme Court justices to 15. The Republican Party gets to select 5 of those. The Democratic Party gets to select 5 of those. And the 10 who are selected have to agree on the final 5. It's intriguing. It presents a lot of different strategic possibilities. But again, the question is, will this depoliticize the court or just make those 5 in the middle super, super, super important, right? And so the commission could explore all sorts of things, including just changing the voting requirements on the court itself. So instead of a simple majority, 5-4, to strike down a piece of legislation, they could require 6-3 or even 7-2 to strike down a piece of legislation. So everything's kind of up in the air and up for discussion right now.
Okay, so our colleague Mike Salamone actually asks about the possibility of impeaching justices. A little over a year ago, there was a lot of talk about possible impeachment of Justice Kavanaugh. Mm-hmm. Is something like that likely to happen, do you think?
It could happen. I think there are political costs to that are greater than the costs to expanding the courts. Impeachment, as we saw with President Trump, has become a vehicle for kind of partisan airing of grievances, but doesn't seem to be a very functional weapon unless you control the House and the Senate. If the Democrats take the Senate, they could very well impeach and convict Brett Kavanaugh, and they'd impeach and convict him for presumably lying during his confirmation hearing, right, committing perjury. They could go back and do the same thing with Clarence Thomas, presumably. As I mentioned in my talk, there's been such an escalation, right, between the Democrats and the Republicans over the course of the last 10, 12 years, especially. I wouldn't put it outside of the realm of possibilities, but if I'm a kind of Democratic party activist or politician, I would pursue more of a structural reform to the court, and rather than drag these justices through another highly charged partisan impeachment. It also opens the door for the Republicans the next time they gain control to just impeach the Democratic justices.
Yeah, of course, given the fact that FDR couldn't get court packing through a Congress stacked with New Deal Democrats, what's the likelihood of any kind of institutional change to the court really politically really taking effect?
Yeah, Laura Kelman was talking about this on Friday. She's written an entire book now on the New Deal court packing plan, and she's dug really deeply into it. And one of the things to remember is that the FDR coalition, yes, it was a very strong coalition, but it was also a coalition of liberal Republicans, conservative Democrats, who had these different constituencies that they were trying to satisfy. The partisan sorting has become such that if, as we saw, McConnell guaranteed the votes for a nominee before he even had a nominee, right? He said, we've got the votes to confirm someone to the Supreme Court before we even knew who it was. That shows you where partisanship is now, and how if the Democrats from the top down decide this is something they want to do, they're likely to fall into lockstep. Now, expanding the number of seats on the Supreme Court, again, invites the Republicans to do the same. One of the things that I've been interested in thinking about is what it would look like to expand the Supreme Court, but tie those seats to term limits, to say every new seat created will be staggered. 2 will serve for 6 years, 2 will serve for 10, 2 will serve for 18, and then every seat thereafter would then roll into these sort of statutory term limited appointments, which, yes, packs the court, but also sort of restrains those appointments in a particular way. So that's an interesting possibility.
Okay. So Joshua Heiler, he asks, a question about, the fact is that we've been seeing over the last several decades, increasingly lots of political policy issues being shunted off to the courts, and for various reasons. He asks whether or not this implies serious problems with the common law legal system at a more fundamental level, and whether or not Americans might start thinking about the entire legal system in a more fundamental way than they have in the past.
Yeah, so the trends you note are exactly on point, that you see an increasing number of policy issues being resolved through the courts. And this is for a number of reasons. I haven't really thought about it as a function of the common law system per se, but it's certainly a reflection of what's happening in our politics. So as I mentioned, polarization and gridlock in Congress means that fewer and fewer kind of policy agendas are able to make it through those avenues, right? The roadblocks are left, right, and center. And so policy entrepreneurs are looking to the courts increasingly to try to pursue their policy agendas. Pursuing policy through the courts also insulates it from potential losses in the next election. So even if you're a majority party now, because of this concept of competitive parties and insecure majorities, you don't know if you're going to be a majority party for very long. Getting policy through the court creates precedent, as Cornell was just saying, and presumably insulates it for a period of time under the doctrine of stare decisis, let the decision stand. And of course, political losers increasingly are turning to the court because they can't push their policy through the court. So it's a function of that. It's also a function of Congress creating rights to sue, right? So this is Tom Berkey's work on litigious policies. Congress has increasingly tried to resolve major policy issues by creating federal rights to litigation. So we're not going to create a bureaucracy to oversee this because that's big government, but we Congress people can create the Americans with Disabilities Act, right? Which looks like we're doing something to address this significant issue of access for folks with disabilities. But instead of creating a major bureaucracy within the government, we'll just create rights to sue. So it pushes all of that into the court. So I think there's a lot of dynamics at work. And maybe it is a function of the common law system too, but I haven't thought that through.
Yeah. So Madison Rasmussen asks about the opposition to Judge Barrett. How much of that do you think is about her conservative legal and political views? How much of it is about how close it is to an election? In other words, assume President Trump appointed a less conservative judge, somebody who was moderate, a Garland type figure. Yeah. Would there be so much controversy about this nomination right now?
I was exactly thinking of Merrick Garland when you were talking. And this gets to this kind of broader question of where are all the moderates? And because of the dynamics and the trends that we're noting, these same trends are manifesting themselves in law schools, legal training, the legal profession, that because of the rise of the Federal Society for Law and Public Policy Studies and its counterpart, the American Constitution Society, law students from very early on really have to pledge allegiance, particularly to the Federal Society, if they ever care about advancing their career into a government job in a Republican administration, a clerkship, or a federal judgeship. So these dynamics have hit the law schools too. And what you're seeing is an increasingly sordid legal profession and judges and justices who have increasingly signaled their credentials to one side or the other. Now, Cornell, you mentioned Merrick Garland. He's about the only person that popped to mind as you were reading this question that I could think of, who's also, by the way, available and seems interested in a Supreme Court position, as we know from the Obama administration, who President Trump may have selected. And I do think Democrats would be better with that than the alternative. When I was testifying in front of the House Judiciary Committee, it was just 4 days after Ginsburg's death. And it was a hearing that was meant to be about court capture, judicial independence, and the rule of law. And it turned into a major hearing over the impending battle with this seat. And one of the points I made is Levitsky and Ziblatt, political scientists, wrote a book called How Democracies Die. And one thing they note is that democracies die because the norms of mutual toleration between opposing sides and the norms of forbearance, right, fall away. So this idea that the Republicans literally could have filled that seat with anyone, and they chose to, but they filled it with the most stalwart conservative person they could think of. Instead, what they might have done is what Cornell suggested, and backed off their power a little bit for the sake of kind of the future relationship between the parties and the institution itself. So they could have appointed a centrist like Garland and still gotten some of what they wanted, but not going full constitutional hardball.
Yeah. So, so Democrats like to point to the Merrick Garland nomination as sort of starting the nuclear option, the escalation of partisan tension over judicial nominations. Republicans like to point to Judge Bork's nomination back in 1987. So, and there's some evidence, a lot of evidence to suggest that's actually when Republicans in the Senate started treating nominations very differently. But what's your take on all this? Is there a point where all this began, or has it just been so gradual that it's like a frog in boiling water? I mean,
yeah, I when I was testifying, I was in a fairly heated exchange with Representative Jim Jordan. And he was kind of yelling at me to try to get me to say that the Democrats started it, but didn't they start it? And, at some point I just said, it doesn't matter who started it if it ends in mutually assured destruction, right? That was sort of my take on it was, each side is going to create the narrative that benefits them. And so the Democrats will point to the scuttling of Garland. Garland, by the way, he was not the Amy Coney Barrett of the left. This is evidence already that Obama picked a nominee that was centrist, that was already a compromise candidate. And the Republicans said, no, I don't care who you pick. Right? We're not hearing it until after the election. Let the people decide. They should decide who fills that seat. He could have picked Pam Garland, right? Pam Carlin from Stanford Law School. He could have picked Brian Stevenson, or he could have picked a really sort of energetic, deeply progressive nominee, and he didn't. He picked a consensus nominee. And to the conservatives, when I was researching my book on the Federalist Society, back before many people knew about the Federalist Society, they did point to Robert Bork and the failed nomination of Bork in 1987, the way he was treated by Democrats, the kinds of campaigns that media campaigns, public campaigns that were mounted against Bork. But what they don't talk about is that the opposition to Bork was bipartisan. Right? There were Republicans and there were Democrats who opposed his nomination. And so, yes, the dynamics of kind of escalating and getting organized interest groups involved in a major way to oppose a nominee, that did seem fairly new and fairly dramatic with Bork. But the opposition to Bork, the resulting opposition, was actually bipartisan. Whereas, as we saw with Garland, this was McConnell, straight down party lines. And as we're about to see with Barrett, it will be almost entirely straight down party lines.
Yeah, but a lot of that has to do with the sorting of the party, or in the meantime. But so Ashley Willoughby actually asks about this. I don't know what they call it, if they call it the McConnell rule now or what it is, that you shouldn't nominate somebody in the year of an election, right? And now that's been violated, and he's got a caveat to it. Well, now it is. You shouldn't nominate. Well, you can go ahead and nominate, but the Senate shouldn't hold hearings unless they're of your same party, the president's party. Is there any way to have some kind of institutionalization of a rule like this, one way or the other, to clarify what's acceptable and not acceptable during an election year in terms of Supreme Court nominations?
That's an interesting question. And I think the reason we're asking it is because of the breakdown of norms. I mean, previously for years, there were informal agreements between the parties that they would treat nominees a particular way, that they would treat the process a particular way. And as we've seen, those norms have really broken down. And so your question is, do we need formal rules? And could we even have formal rules? I haven't thought about it, but my sense is I don't think there's any formal barrier in the Constitution to Congress as part of a judiciary act, kind of binding the Senate, binding itself to some kinds of formalized or regularized rules and proceedings. Could that be part of Joe Biden's courts commission? Perhaps. I think the Democrats would be fairly disappointed if that's all that comes out of that commission after 160 days. I think they are thinking big and are already disappointed that Biden wants to wait and have a commission. But those are the kinds of things that can be done around the margins, I think, that would benefit both parties and that would regularize the process to a certain extent.
Yeah. So Connor Simmons asks specifically about the right to privacy and what the future of it is. And I think his question goes to the fact that it's an implied right. It's not mentioned in the Constitution. One that's more vulnerable to originalists who like to also think of themselves as textualists in terms of their constitutional approach. So what do you think? What do you think about that? Do you think it's really vulnerable, the whole idea of a right to privacy?
I do, and I think for many reasons. So first and foremost, we talked about Robert Bork. One of the reasons that Bork was borked was because he outright said and had written that he believes there's no such thing as a right to privacy in the Constitution, that this was an act of judicial activism. It was a bunch of justices on the Supreme Court reading into the Constitution what they would have liked to have seen. And so it has become the foundation for a lot of decisions that conservatives would like to see gone. Roe versus Wade, first and foremost, right? Griswold versus Connecticut is the underlying principle that allows the court to kind of extend and apply it to a woman's right to choose an abortion in Roe versus Wade. But it also it was the foundation of striking down sodomy laws in Texas. So the decision that struck down kind of the Texas sodomy law and allowed same-sex couples to sort of privacy in their intimate relationships. Like that's a sphere that government shouldn't be able to regulate. And again, Kennedy, who's now left the court. And then also eventually becomes the foundation of, or at least one of the foundations of same-sex marriage. Certainly not the only one, right? But so in that regard, if you undo Griswold and you overturn the right to privacy as it's become applied to these other precedents, then you really shake the foundations of those other precedents. And you make it easier, as Cornell mentioned, to overturn stare decisis, right? To break the doctrine that the decision should stand. So I do think that it's a target. I also think it's vulnerable. And this says something more about where the kind of liberals were in the 1950s and 60s in terms of constitutional jurisprudence. It's vulnerable because the opinion that Douglas writes talks about how the right to privacy is found in penumbras, in emanations, right? It's not in the Constitution, but it's like that shadowy reflection of a celestial object when the moon shines on it. It's like that shadowy, indefinite part. That's kind of like where the right to privacy is. So if you look at the Fourth Amendment and you look at the Ninth Amendment and you look at parts of the Fifth Amendment, there's this like penumbra. And that's where the privacy right is. And so because of that justification, it's opened itself up to a lot of criticism from sort of textualist conservatives who like to say, really, penumbras, emanations, that's what we're working with here. So I do think it's vulnerable for those reasons. And also I'll note that this was the one part of the confirmation hearing where Barrett declined to call it a super precedent, right? She said that Brown versus Board of Education, okay, yep, no, that's a super precedent. And then she acted like she didn't know what a super precedent was when they asked her about Griswold versus Connecticut and the right to privacy. So I think she's tipping her hat there too.
So Tim Peckinpah asks a question about, if Democrats are very concerned about advancing their liberal policy agenda, what would be more important to them in terms of expending political capital? Ending the filibuster in the U.S. Senate or reforming the court?
You'd have to end the filibuster in the U.S. Senate to reform the court.
Yeah.
So those things have to go hand in hand because you can't have a minority party filibustering that. So if you remove the filibuster in the Senate, then you can sort of get court reform through more easily. So I think that removing the filibuster would have to be part of any major court reform proposal.
Right. So Raman Valdez asks a broader question, and she wonders how much of this is really about sort of generational attitudes about politics. The way we think about politics is a zero-sum game. Mm-hmm. If you had a different generation of political leaders in power right now, both in the White House and in Congress, whether or not we'd be seeing this kind of dramatic polarization of all of our politics, but especially with respect to the court right now. Would the younger generation of politicians see these things differently and be more cooperative, do you think?
That's a great question. And I do think that, so political scientists will tell you that our system, the way it is currently designed, the first past the post, single member district, winner take all, the way our system is built right now is built to produce two parties. Right? There are very few options, but to have two parties within our system. So people like Lee Drutman, who was my colleague at Berkeley and Mike Salamoni's colleague as well, has written about kind of breaking the two-party doom loop, right? And how do we do that? But you have to have structural reform to the system itself, which is big, right? So that's a big thing to do before you can make space for multiple parties. Right? And my sense is that with multiple parties, at least the effects of affective polarization would be decreased because it's not you're either Coke or you're Pepsi and Coke hates Pepsi and Pepsi hates Coke, right? There'll be multiple different beverages for you to perhaps align with on certain issues and then align with other beverages on other issues. So I think it's part and parcel sort of the structural determinants of our two-party system. And then as Cornell has written about and as political scientists have written about, it's what's happened with those two parties and the sorting that's produced political polarization, parties moving further away from each other, and then the resulting affective polarization or tribalism. And you know, I would say to you also, the phenomenon is not limited to politics. Everything, it affects everything. It affects sports, right? If you're watching the NBA, Black Lives Matter, right? If you were watching the NFL, either before the Black Lives Matter movement or after, when Goodell said, no, it's okay now, players can kneel. It affects consumerism, right? What products are we going to buy? Oh, Nike's supporting Kaepernick. He's on my side, but you know, Reebok or Adidas. So it's really like nefariously filtered into every part of our lives right now. And I think
including wearing masks, by the way.
Masks are polarized. Yes. And I will say, Cornell, one brief thing is, so according to Liliana Mason, who wrote a great book called Uncivil Agreement, how do we get out of this? Affective polarization. You need a superordinate goal. You need something that's so big that it would bring all of us together. One would think a global pandemic would be the superordinate goal, but instead of bringing us together, it's further polarized us, as you say, with masks. So I don't know the answer to your question, but I know there are really smart people out there who are trying to figure this out.
Okay, so let me ask you a little bit, drawing on the work from your most recent book. So, two questions. One is, what do you think is the most important goals for the religious right now in terms of Supreme Court decisions? And how far do you think the court is likely to go in the near future in terms of redefining religious liberty rights?
Mm-hmm. Yeah, so I think you in part answered one question, which I would say on the Christian rights agenda, first and foremost, returning God to the public square. That's sort of how they put it, which is, you know, for a while we banished God from schools, we banished school prayer, we expanded kind of the Establishment Clause in a way that threw up a wall that has made government hostile to religion. And so part of it is sort of chipping away at the separation of church and state. And you've already seen some decisions like this. There was Trinity Lutheran v. Comer, which said that a state could not restrict new playground funds. It had to allow churches who had playgrounds to apply for this taxpayer funding, which in an older era of Establishment Clause jurisprudence would seem as a pretty straightforward violation of the Establishment Clause. But they said that if they didn't, it would be religious discrimination. Sort of large crosses on public property, they upheld taxpayer dollars going to maintain that. So they're already starting to kind of chip back on how big the Establishment Clause is and how it limits government-church interaction or even government sponsorship of religion in churches. And then what we've seen is that the flip side of that coin is religious liberty, right? The idea that you can sort of carve out exemptions to otherwise generally applicable rules, regulations, anti-discrimination statutes based on a person or a corporation's professed religious liberty beliefs. So this is Masterpiece Cake Shop, where the baker was ruled to be exempt from Colorado anti-discrimination law because baking a cake for a same-sex couple would violate his sort of expressive speech. Similar dynamics at work in Hobby Lobby, right? The Hobby Lobby did not have to comply with the Affordable Care Act's contraception mandate because Hobby Lobby was a small, closely held for-profit corporation that was deeply religious, had deeply religious beliefs. So they could use that to claim an exemption from federal law. So I think those things you're very likely to see expansions of those kinds of things in the future. And then of course, what we've already mentioned is the undoing of much of the culture wars. So abortion, contraception, same-sex marriage. I think these things are all very much at the forefront of what the Christian right wants and why they've worked so hard to try to invest in courts and lawyers and litigation over the past 30 years.
So Seton Parsons, he notes that we've been talking mostly about the Supreme Court,
Mhm.
And he's concerned about lower courts. Can you say a little bit about lower courts? And in particular, some discussion about the need to expand the number of lower court judgeships in particular in the next administration.
Yeah, so this is an area where deeply impactful, particularly if Congress, if on its bucket of reforms, a Democratic-led Congress and presidency decides to maybe jurisdiction strip from the Supreme Court of the United States to limit the kinds of cases it can hear, then what would happen is that those decisions at the lower courts would become more and more final and more important. And the same kinds of dynamics that have affected the Supreme Court have also affected lower federal courts because the processes are exactly the same. And so what you've seen is, again, a more, over the past 4 years, Trump has had over 200 appointments to the lower federal courts. Many of those vacancies were intentionally left open by Mitch McConnell in a gamble that he won, and that they would be filled by a Republican president. And so the same kinds of dynamics that are at play in the Supreme Court right now are at play at the lower federal courts. There is a good governance rationale that a lot of folks are talking about for expanding the lower federal courts, in part because they're overwhelmed. They can barely keep up with their caseload. They've been asking for help for years. And so the idea that the Democrats could reasonably expand the seats on the lower federal court, thereby creating new judgeships for them to fill, would also satisfy these sort of good governance, good government rationale. So I think you're likely to see a court reform plan that targets not only the Supreme Court, but also the lower federal courts as well.
Okay. Well, I'm afraid our time's about up. Before I thank our guest, let me remind you that we have one more event this week in this series, and that's on Wednesday. We have Travis Ridout and Katie Searles, who's going to be talking about the role of media in the election. And then we'll take a week off, as next week's, of course, election week on Tuesday. You should vote then or before, hopefully. And then we'll be back on November 10th for this series, where we'll have a panel of experts breaking down the election and what happened in the election. So I encourage you to join us for that. Let me thank Amanda now for a really stimulating, interesting conversation about the Coney Barrett nomination and the role of the Supreme Court. It's been fascinating. I really appreciate it, Amanda.
Thank you for having me, Cornell. It's been a great discussion, and thank you to everyone for tuning in. And yes, go vote.
All right, thank you, and we'll see you all on Wednesday.